we have 2 meetings left, today and next week. Today is divided between 2 topics. The first one is this presentation, the illegality of forced displacement. Generally, we talked, about forced displacement in 2 sessions. We talked about wars. We talked about home demolitions. We talked about the different laws that are designed to inflict the displacement. So today I'm going to talk about the illegality of this policy. Obviously, it's clear that I'm already giving my judgment before we go. So I didn't say the legality or the illegality. I'm giving the judgment, so I'm going to be giving arguments. Obviously, I'm sure many people who like forced displacement and like ethnic cleansing will say, no, it's legal. And this argument exists. But obviously, I'm going to give you the opposite argument. The argument that it is illegal.
Wait just a moment. Isn't the law clear about it?
It is, in my opinion.
It's not an issue of whether it is or isn't.
Well, then, Maho, if we all agree that it's illegal, then why is right of return a disagreed topic until now? And because, again, right of return will not be the topic of today. It will be actually the topic of next time as a remedy to the whole displacement issue, as well as other remedies that we will discuss. It will be something, next time it will probably be more interesting. I will talk about the peace process, the way the peace process dealt with the different waves of displacement, because, generally we all know that the refugees were postponed to the last stage, but that's not the full picture. There are several elements that were discussed in the peace process, so I will talk about all of them, and then I will talk about what expectations from a human rights perspective we would have, and we will have a discussion about it. So that will be in the last, in the last session, I'm sure maybe some people will like what I will say, some people will dislike, so maybe I will also open more space for discussion, despite the fact that discussion is always open. Anybody wants to object to something I say can stop me and tell me you're wrong. That's always, that's always, But yes, there is always a discussion about what is legal, what is illegal, and that's why forced displacement is continuous. And for example, and that's something I will also be talking about. Israel doesn't recognize the applicability of the Fourth Geneva Convention, which I will talk here about, in the occupied territory, and it doesn't recognize the applicability of a specific article that I will talk about. So in that case, the official position is that this forced displacement that we're doing is okay. Despite the fact that Israel wouldn't normally say we are doing forced displacement, we say this deportation. Usually, this specific deportation is different from what others did in the horrendous things. But anyway, I will go through now a little bit more historically about forced displacement, how it became illegal over time, and I will go through the concepts of war crimes, crimes against humanity, and other elements. I'm not sure how many of you are aware or not aware of these concepts. I'm sure I'm sure you know something about them. And then the second section will be about the refugees in different places, the UNRWA, the United Nations Work and Relief Agency. As I told you before, I tried to seek someone from the UNRWA to speak, but I didn't manage, and I didn't manage to find other speakers. So you're stuck with me today for the whole session, for the whole 3 hours. And next week, as I told you, it will be more about remedies and the whole Israeli-Palestinian peace process and beyond the peace process. So back to today, the illegality of the forced displacement. When did this illegality start? Usually it is traced back to the Hague regulations, the illegality of the forced displacement. The Hague regulations are one of the most important and early instruments of international law, of a specific type of international law called international humanitarian law, which is the law that is applicable at times of war and occupation. And according to the Hague regulations, this article says family, honor and rights, the lives of persons and private property, as well as the religious convictions, please come in, and practice must be respected. Private property cannot be confiscated. This article, despite the fact that it does not mention explicitly forced displacement, was interpreted later that it actually prohibits, it's a prohibition of forced displacement.
Which article is it?
I think it's 46, if I am right. I believe it's 46. I'm not 100% sure that this is the right number. And it was cited actually in the Nuremberg trials, because the Nuremberg trials took place when there was no explicit text that prohibits forced displacement. I will talk about Nuremberg trials later. It was cited as one of the sources of why forced displacement is illegal. Obviously, in the Nuremberg trials, as I will mention later, forced displacement was actually condemned. But then in 1919, there was a commission that also considered deportation of civilians as a breach of the laws and customs of wars and the laws of humanity. This was the stage of after World War I. In World War I, as we know, there were important crimes that took place. We all probably know about, the genocide of the Armenians or other important atrocities that took place, and the international community started to try to regulate the issue, the different crimes. And after World War I also, it was the time when there was an attempt to prosecute individuals who might have, who had allegedly committed two types of crimes: war crimes and crimes against the law of humanity. The 1920, there was a treaty called Sèvres. That's a French city, is it?
Yeah.
French, yes. And according to this treaty, it was the forced displacement was condemned, basically, as the text. Maybe someone can read this text for us, if, anyone, please. Can you?
Absolutely.
Yes.
The victors of the First World War signed the Treaty of Sèvres, which included among its provisions the repatriation of all Turkish subjects of non-Turkish race who have been forcibly driven from their homes by fear of massacre or any other form of pressure since January 1st, 1914.
So here, initially, there was also the recognition of the right of everybody who was a citizen of the Ottoman state and who was displaced forcibly from the Ottoman state. There was a recognition of their right to return, basically. And it was also considered a crime. The forced displacement was considered one of the crimes that should be, that people from, that criminals from the Ottoman army should be prosecuted upon. However, then there was the Treaty of Lausanne. Turkey fought a war of independence, and it had some important success in that war, and it never ratified the Treaty of Sèvres. Instead, it even ended up starting a new treaty called Lausanne, and according to the Treaty of Lausanne, there was an amnesty granted to every person who would have been accused of war crimes or crimes against the law of humanity, as it was termed at the time. Also, the Treaty of Lausanne did something very dangerous, which is that it accepted some exchange of population between the Turkey and Greece. And we all know that there are many people who would put this also as an argument that, this is what international law is about, despite the fact that this is what a treaty between, a specific situation came out of, out of conditions of war, rather than general international law actually recognizes. So at that time, the whole issue of criminalizing, condemning forced displacement was weakened a little bit. But it's important to note, and normally scholars of international law would stress on this, that the fact that the criminals were given an amnesty actually means that forced displacement was actually a crime at the time. It wasn't simply an illegal act, because if it was a legal act, there is no need for amnesty. Amnesty is given for a crime. It's still a crime, but you don't get punished for it. So this is an important difference to notice.
Munir?
Yes.
You said that the exchange of population between Turkey and Greece was dangerous. Do you mean it was like a dangerous precedent to set?
It was a dangerous precedent to set.
Can you say a little more about why?
I know that, I know for sure that in Israel, there was the idea, it was considered in the 30s actually, even before Israel was established, when we were still under the mandate of the Brits, the Zionist movement already started thinking about transfer, and it wanted to exercise an exchange of population. Basically, Israel wanted to be a Jewish state. There were many other Arab states around it. It thought, we will send these, we will send the Arabs there, we will get all the Jews from the Arab countries, and it will be resolved. Obviously, this is not what the Palestinians wanted. This is not what the Arabs wanted, and nobody could accept a proposition like that. However, you will still hear until today that this was actually an exchange of population. I don't know how many of you have heard about that argument. That this is, you have, yes? That this is an exchange of population happened. 700,000 Jews came from the Arab countries, and 700 Arabs went to the Arab countries, and
it's not the way I know it. It's not framed as an exchange of population. It's framed as a balancing of refugees.
Yeah.
Like if we recognize some rights of the Palestinian refugees, we want the right of the Jewish refugees from Arab lands in return. That's the way I know it is framed.
I've heard the argument of exchange of population actually before, but obviously there is, in an exchange of population, you will need somebody else to accept that exchange, and there was nobody else to accept it. The Arab countries always maintain that they insist on the right of return. The Arab countries until today, most of them don't want the refugees to stay in their countries. So, obviously the refugees themselves have always insisted on the right of return, and have not accepted to be basically patriated somewhere else. So it never worked. This wasn't the case, but historical research also shows that the Zionist movement in Palestine really, really discussed the issue of transfer as a solution. Greece and Turkey were one of the examples they thought as a precedent. And obviously, later on there was the issue, there was also in India and Pakistan, there were populations moving across the borders, Muslims going to Pakistan and Hindus going to India. But what I would say is that this is equal to any violation of international law. If a certain state is basically torturing its population or torturing anybody, it's illegal. The fact that it is actually happening doesn't make it legal. The fact that something, a violation takes place of rights, of human rights, doesn't make that violation legal. It just means that it is happening. Now, these were the things that the international community tried until after the First World War. The international community did not succeed to prosecute people who committed war crimes and crimes against humanity. But then we had the Second World War, and in the Second World War we had the atrocities of the Holocaust, as well as other atrocities that happened. Basically, many parties of the conflict and of the war committed different types of crimes, but Germany and Japan lost the war, and the winning powers decided to actually prosecute criminals of war crimes and crimes against humanity. So this is crimes against humanity came into become a new term of what used to be called crimes against the law of humanity after the First World War. This is the new term that came up. The London Charter is actually the law that that was used in order to prosecute the criminals of the Nazi regime, as well as criminals the London Charter was only for the Nazi regime. London Charter condemned deportation. It used the term deportation and condemned it as a war crime and a crime against humanity at the same time. But what is the difference between a war crime, between deportation as a war crime or deportation as a crime against humanity? It is a war crime when it is conducted in an occupied territory, mainly. This is according to the definitions that existed at the time of the London Charter. It is a crime against humanity if it is done against any civilian population, including the civilian population of your own country. And this is something also, this is important to notice. Traditionally, in international law, states used to believe that they are sovereign and that there is nothing, nobody, no outside state can come and tell me what to do in my own country and to my own population. This is an original old principle of international law that existed always and still exists. But then, especially after World War I, well, starting from after World War I, but especially after World War II, this idea of absolute sovereignty that is that cannot be argued or cannot be discussed started to fade down. You cannot massacre your population. You cannot kill your population. You cannot have a genocide on your population. You cannot deport your population. And that's the whole idea of why crimes against humanity were actually invented. The concept of crimes against humanity, because originally there was something called war crimes. Two states are in a conflict, in an armed conflict. One of them violates the laws of war, international humanitarian law, which we mentioned earlier. A grave violation of this law is considered a war crime. But then the international community understood that war crimes are not sufficient to define what atrocities can happen. They are not enough to cover these atrocities, and that's why the idea of war crimes against humanity came into being. But with crimes against humanity, the standard of defining a crime is a bit higher than war crimes. In war crimes, one single grave breach is sufficient. One single act. So one deportation of one person is a war crime, right? There is two deportations are two war crimes. In crimes against humanity, if international humanitarian law does not apply, and if the state is doing violation against its own population, crimes against humanity would be only defined if it fulfills one of two conditions. If it's systematic or widespread. These are the two conditions. Systematic means that it is organized, it is designed, it is planned. Widespread means a large number of people. which we don't exactly know. It's not defined. There is no quota. We don't know that 10 or 20 or 30 or 100 or more million. We don't know, but generally these are, you know, that's the criteria. If a crime is conducted in a widespread scale or systematically, then it can be considered a crime against humanity, whether in an occupied territory or any other territory, any other civilian population. The only thing is that it has to be a civilian, the victims should be a civilian population. And I believe this is important for our discussions. We mentioned forced displacement also that took place, you know, during our two first meetings that took place in Israel, in the areas that Israel claims its sovereignty, and in the occupied territory. So in that case, we are talking about both types of crimes, war crimes and crimes against humanity that are being committed.
Munir, but this makes an interesting question about the original Nakba, about the 48 Nakba.
Yes.
Like it looks like May 15 was a watershed, because after May 15, Israel deported its own, well, they weren't quite citizens, but its own population.
Yeah.
But before May 15, they had already expelled about half of the Palestinians. So what was, how would international law regard what was before May 15, 48?
That it was mainly, well, first, when we talk about war crimes and crimes against humanity, we're talking about individual responsibility. So it was individuals who conducted these crimes are responsible criminally for their actions. But for the other type of responsibility, which is something we will also discuss next time, the state responsibility on these cases, the state also takes responsibility on the actions that happened during its foundation and in the events that happened to actually establish this state. So this also, you know, this is mainly what it is. But when we talk about war crimes and crimes against humanity, we're talking about criminal law. Criminal law is not something that a state only is responsible of. The state has its own responsibility to compensate what happened, basically to redress the victims, basically. But there is another level of responsibility, which is individual. The person who actually was responsible of the crime would be considered criminal and should, you know, be prosecuted.
But by that you mean also not only the actual individual who did it, but let's say the minister who is responsible for it.
Yes, indeed. And this principle also was confirmed and in this stage of the history, in the stage of after World War II. It was very clear that nobody was immune from being prosecuted as a war criminal or, you know, criminal against humanity, crime against humanity. That there was no immunity. You can be the president, the head of state, your immunity is lost. You could be prime minister, you could be minister of defense, you could be a small soldier. Any person who is involved in a crime is responsible, regardless of which level of responsibility he has. This was confirmed, you know, this was confirmed in the after World War II trials. And all these principles that were confirmed in the Nuremberg trials and the Tokyo trials were also adopted by the General Assembly in a resolution. Its number is 95. And the International Law Commission in 1950 also studied the principles that came out of the trials of Nuremberg and Tokyo and confirmed them as being expressive of customary international law. And customary international law is a very important term. Maybe I should stop and explain it. International law comes from several sources. When we define what is international law, it comes from several sources, mainly treaties that a country will sign itself. That's one important source of international law. Another one is called customary international law, which means basically a law that maybe is not necessarily written. It's not necessarily written. It's not necessarily signed upon. But all the states understand that this is the law. There is some acceptance, wide acceptance among the states that this is the law. Obviously, it can be written later and codified, but it should be practiced widely and recognized as law. And one of the ways we can recognize that something is customary international law is through UN General Assembly resolutions. When the General Assembly decides to adopt a legal principle and say the principles that came out of the Nuremberg trials are actually expressive of international law, this actually means that this is customary international law. And this has important significance even for us. There is a case that I even forgot to put on the slides, but although it's very important. There's a case in Estonia. Estonia gained its independence from the Soviet Union, and later on it issued a law, an internal domestic criminal law, that according to which they could prosecute people who had committed war crimes or crimes against humanity. I think it issued the law in 2002. That's why I should write on slides, because the numbers I always forget. But if I remember right, I think it issued the law in 2002, and later on it prosecuted somebody who allegedly displaced people in 1949. What would be a normal argument a lawyer would make to defend the defendant?
Statute of limitation.
That's one thing, but there is no statute of limitation on war crimes and crimes against humanity. What's another one? Retroactive is obviously the obvious argument that a lawyer would make. They would say, the law you issued was in 2002. It's retroactive. You cannot punish someone on something that was not a crime before the criminal law. صح? And obviously, this is basic law legal knowledge. If something is not a crime today and I do it, and tomorrow the criminal law comes and criminalizes this law, this act, I cannot be prosecuted and punished for the act that I did today. I cannot do it tomorrow, but today I can. It's not a crime. The domestic courts rejected this argument, and this was taken to the European Court of Human Rights. What did the European Court of Human Rights say? It said that no, this is not retroactive. Already but after the Second World War, forced displacement was considered a war crime and a crime against humanity. And this article 59 of this resolution 59 confirmed it, of the UN General Assembly. So it was customary international law already, and therefore prosecuting this person for a deportation that took place in 1949 is appropriate. And it kept the judgment of the Estonian court. So
the argument of retroactivity was even raised in Nuremberg.
It was
regarding
also
crimes against humanity.
And yes, that's true, and it was rejected. It was also because the London Charter was actually written after the war was finished, after Germany had already lost the war, and and the winners won and the losers lost, and the courts were being built, right? So the issue of retroactivity also came then, and it was rejected. It was said that no, these were illegal before the war, and they were crimes before the war, and hence this means that already from the time that the World War II started, we know for sure now that from international law point of view, forced displacement was illegal. Now
excuse me, because that was in 1914?
No, two. We're saying World War II.
No, but you say even the Nuremberg...
which happened after the World War II.
Right. But why do you say because the law had already been in place?
So it wasn't written law.
It was customary law.
It wasn't written, it was customary. Okay. Yes, there was no written text. Before the Second World War, there was no written text clear, other than the one that I showed at the beginning, at the first slide, which you missed. There was no other text, but it was customary. So this is, this is the idea. And the only term that existed was deportation at that time. But it was also understood that deportation also included movement to outside the borders and movement inside the borders of a state. But this was a little bit further developed after. Okay. I will go one more actually. Maybe someone can read this for us from the Nuremberg trial. Who would like to volunteer to read this for us? It's relevant to us. Okay, there are no other volunteers.
In certain occupied territories purportedly annexed to Germany, the defendants methodically and pursuant to plan endeavored to assimilate these territories politically, culturally, socially, and economically into the German Reich. They endeavored to obliterate the former national character of these territories. In pursuance of these plans, the defendants forcibly deported inhabitants who were predominantly non-German and replaced them by thousands of German colonists.
So this was basically, a condemnation of the Germanization of occupied territories. And I put it because it's also, relevant to us. So, and this is the citation, obviously, of this text. Okay, then we have the Fourth Geneva Convention, which is a very important tool in, again, international humanitarian law, which I mentioned earlier. According to the Fourth Geneva Convention, Article 49, individual or mass forcible transfers, as well as deportations. Forcible transfers and deportations. Forcible transfers are forced displacement within the borders of a specific territory, of one territory. Deportations is the forced displacement beyond the borders. So a deportation would be to another country, basically, in the simple words. And the transfer would be within the borders of the same country or the same territory. So individual or mass, look at the beginning, it says individual or mass, and this is here we're talking about war crimes. One deportation is already a violation. Individual or mass forcible transfer, as well as deportations of protected persons. Protected persons are the civilians, basically, and other types of persons that are considered protected in an occupied territory. From occupied territory to the territory of the occupying power, or to that of any other country, occupied or not, are prohibited regardless of their motive. That's it. Prohibited regardless of their motive. So this is a very clear text in the Fourth Geneva Convention that prohibits any displacement, even one.
And it's like the subtext there reads a little bit differently, which is interesting.
Which one?
In occupied territories, civilians not taking part in hostilities must be spared and protected.
Which feels just like a little bit of a clause or something. I don't know. There's something about that.
Just a general.
It's a general
statement of the Fourth Geneva Convention.
Yeah.
Who's a protected person?
Yeah, IHL, International Humanitarian Law, is all about protecting people who are not part of the hostilities. Now,
Right.
The idea is that while killing is bad, in wars, killing is not considered illegal if it is directed towards combatants, people who are taking part in hostilities. Soldiers, you can kill a soldier legally in a war, unfortunately, but this is the case, right? This is the law. The law of international humanitarian law did not consider. Can you go back, please? International humanitarian law did not consider war itself illegal, but it rather tried to regulate. It's a way to regulate war. This article, by the way, now something I should talk about now, and I will talk about more in our next meeting as well. That Israel always consistently has refused, generally, international humanitarian law, or generally, let's say the Fourth Geneva Convention, the applicability of the Fourth Geneva Convention. And more specifically, this article was brought in front of the court, of the Supreme Court several times, and it was always not considered part of the law that the court will decide on. So when Israel deported individuals, and the lawyers like Felicia Langer or many other lawyers went to the court to argue for the return of that person, the court refused that this is even applicable in the first place. So that's something we should always remember when we...
On what grounds?
Israeli Supreme Court.
On what grounds?
It also interpreted it in a way that would not apply, not only that it's not applicable, but some weird interpretation.
Yeah, Meir Shamgar tried to interpret it in a way that this is something that came to respond to the atrocities that happened in Nazi Germany, and it is more about deportations for labor. That's what he interpreted it. Because this is the text that was written actually in the Nuremberg trials on the definition of war crimes. It was for deportations for labor in occupied territories for labor or other purposes. So although the text here says regardless of the purpose, but he did the other interpretation, but also he said that the whole article is not applicable in the first place. And therefore, it's very important. By the way, the same article also prohibits the transferring a state's own population into the occupied territory, which is basically building settlements. So, from the Israeli strategic point of view, in the colonization of the West Bank, this article should not exist. It has been rejected consistently because it is important. It is basically against the colonization of an occupied territory and the deportation of civilians from the occupied territory or within the occupied territory. So if this was respected, many problems that we are dealing with today would not probably exist. But it's not. You cannot use it. You cannot use it in court. You cannot invoke it. It has been rejected several times, unfortunately.
But I think what Israel always claims is that the territories aren't really occupied.
Exactly. Yes. So Israel has sustained...
So that the Geneva Convention doesn't apply to the territory.
Yeah, after the occupation, immediately after the occupation, Israel said we recognize it actually issued a military order that also recognizes the applicability of the Fourth Geneva Convention. But very quickly after that, it revoked this and changed this principle and denied quickly the applicability of the Fourth Geneva Convention. They depended on a few opinions. One of them was somebody called Yehuda Blum, who was basically a professor at the Hebrew University at the time, and who wrote a paper basically saying that international humanitarian law was there to regulate two elements, two issues. One of them is humanitarian issues, and the second one was the rights of the legitimate sovereign, the legitimate state. And that there was no legitimate state or legitimate sovereign that has a claim on the West Bank and Gaza. And then Meir Shamgar, who became later a Supreme Court justice, and at the time, Meir Shamgar is the engineer of the occupation regime in the West Bank and Gaza. He's the engineer.
The legal regime.
The legal regime of the occupation in the West Bank. Meir Shamgar. He used this argument and took it further and concluded that the Fourth Geneva Convention is not applicable in its entirety. And there was this announced principle that we will only implement the humanitarian clauses that are in the convention, not the other things that might be used to give a legitimate sovereign back the land because there is no such legitimate sovereign. There is vacuum of sovereignty. This is the Israeli argument. There is vacuum of sovereignty in the West Bank and Gaza. There is no sovereignty. Nobody has a claim more than Israel or anybody else. Jordan doesn't have a right claim. Egypt doesn't have a right claim. Supposedly there was no Palestine also to have a right claim. So there is nobody has more legitimate claim, and therefore the law does not apply. Now this has been rejected by the whole international community first, General Assembly, Security Council, all the states, including the United States even. So, yeah. And equally importantly, if not more importantly, the International Court of Justice in its advisory opinion in 2004 also announced that the Fourth Geneva Convention is applicable in all of the occupied territory, including East Jerusalem. So this is, this is the discussion. Israel and its courts do not rule according to this and according to what the International Court of Justice thinks. They rule according to their own domestic legal system. Now, ICTY is the tribunal in Yugoslavia. Also condemned deportation. Now, all the other, as you will see later, all the other international courts condemned deportation and transfers. Deportation and transfers have been condemned since World War II until today consistently. ICTY here, there is. I decided to use this text from one of the cases. Can someone maybe read the text for us?
I'll read it.
Yes, thank you.
The protected interests underlying the prohibition against deportation include the right of the victim to stay in his or her home and community, and the right not to be deprived of his or her property by being forcibly displaced to another location. The same protected interests underlie the criminalization of acts of forcible transfer and other inhuman act pursuant to Article 5I of the statute.
So here, especially in the ICTY, there was no criminalization. There was criminalization of deportation, but for some reason, the text of the charter of the court, of the tribunal, did not include condemnation of forcible transfers. So this was a bit, but then cases of forcible transfers came to the court, and the court also found that, despite the fact that the text did not include forcible transfers, that it's going to use the other inhuman act element to prosecute people who were accused of forcible transfers. So even in this one case where forcible transfers were not written in the text, it was consistently criminalized, even if not as, even if it didn't come in the text. Then there were other also courts that condemned forced deportations and transfers. International Criminal Tribunals of Rwanda, Special Court of Sierra Leone, International Criminal Court. All of these international courts and tribunals condemned forced displacements. In the ICTY, now why do I have many examples or more examples from ICTY? Because really in Yugoslavia, forced displacement was a very important element of the conflict. The Yugoslav, because when the war happened, the civil war happened, and the different entities started to become states, forced displacement everybody wanted to make sure that there were some areas that were clean of the other population, and forced displacement was a big issue, especially in Bosnia. So when the peace process took place, they had to deal with several issues, most importantly forced displacement. And in the criminal tribunals that took place after the war, also forced displacement was an important issue that came, and it was the crime of forced displacement was, and the elements were really clarified very well from the judgments of this court. Forced displacement means carried out by expulsion or other forms of coercion, such that the displacement is involuntary in nature. So what's most important is that a person was displaced without having voluntarily left. If somebody obviously voluntarily leaves, then this is not, it's not a crime. It's not forced displacement. So it is actually the genuine choice that makes a difference here, that makes a displacement unlawful according to the code. The genuine choice of a person to leave or not is what makes something forced displacement. But what also does it mean? Does it mean you have to carry a gun and tell the person leave? Or do other means of displacement also apply? So also in this judgment, the methods include fear of violence, duress, detention, psychological oppression or abuse of power, or taking advantage of a coercive environment. So several methods. If they flee, if the refugees, the displaced persons, flee because of fear, based on something caused to them, this is also considered forced displacement. You don't have to carry a weapon and tell them leave in order for this crime. And obviously you know why I'm saying this, because it's very relevant to our, at least to the wars. Now I finished the issue of international criminal law generally, the main elements of international criminal law. But I'm going to discuss other issues that, who can tell me what's the time right now? Because I can't see it.
8 o'clock.
It's 8? Okay. Good, we have some time for the break. I'm going to go through other elements about the illegality before we take the break. And then we will take a break and we will go to the other presentation. The other illegality that, because I'm going also through the things that we discussed in the first 2 sessions. You remember that we discussed that there was also deprivation from legal status, both in Israel and in the occupied territory. In Israel, what do you remember what happened after the war in terms of citizenship? What happened? What happened to the refugees in terms of Israeli citizenship?
The ones who were inside.
They what?
Which one is it?
The refugees, the Palestinian refugees who were displaced to outside the borders of Israel. They didn't get
They were divided into 3 different residences.
So no, in 48, the Palestinian refugees, they did not get the citizenship. And in 1967, do you remember what happened in 67? Then the residencies, the 3 different types of residencies were defined, right? And some people were given the residencies and others were deprived from this residency, right? So again, is this legal or illegal? Is this type of action legal or illegal?
If I remember correctly, the basis of this was being present or not being present during the census.
Exactly.
So is this legal?
Exactly. Is your actual physical presence, your actual physical continued uninterrupted presence was usually the reason why you would be granted a citizenship in 1948 and a residency in 1967. If you were displaced, if you went to one of these enemy countries and came back, you're an infiltrator. You're not a citizen. You came back, you're a criminal infiltrator in 1948 and in 1967 with the infiltration military orders, right? So there was a prevention from return, and at the same time there was a redefinition of legal status. Now, regarding the citizenship, it is considered that the fact that Israel did not give the Palestinian refugees who were displaced citizenship, it was considered denationalization. But they never got the Israeli citizenship, right? The idea, the interpretation in international law is that they should have acquired the citizenship. And I'm going to explain why. But I'm going maybe first to ask someone to to read to me, to us, the last paragraph here, which is it's a decision from Tel Aviv District Court before the Israeli law of citizenship was issued. Before the citizenship was regulated by law. It was still at the beginning of the state. They didn't know who was a citizen, who was not a citizen, and there was someone who came. And if anyone can actually find me this in Hebrew, I tried to find it in Hebrew because the citation is quite weird. It's international law reports. That's the only citation that I found. So if anybody, I don't know, you're the only lawyer. Who's
There's another lawyer.
Yes. So if I don't know, I really tried to find this. In Hebrew. I couldn't find it. The only paragraph I have is this, but it's very important because this is a case where the Israeli court, before Israel established its citizenship law, decided a case according to the general international law principles. So maybe someone just can read it for us, please.
So long as no law has been enacted providing otherwise, my view is that every individual who, on the date of the establishment of the State of Israel, was resident in the territory which today constitutes the State of Israel, is also a national of Israel. Any other view must lead to the absurd result of a state without nationals.
What does this mean? So this is a conclusion of an Israeli court, and it is the right conclusion. The Israeli court actually at that time found the right conclusion, but then what did the legislator do? It blocked the way into such right conclusions to become binding upon the state and to become more usual. And they defined who is a citizen and who's not. If you left, you're not a citizen, right? But what does international law say about that? International law usually gives every state the right to regulate its citizenship in the way it wants. But there is something called the law of state succession. What does state succession mean? One state ends being a state. One state is born. Not necessarily that one state ends. One state is born either by one state ending and being divided into several states, or one state gets independent from another state, right? Let's imagine, just for the sake of where are you from in the United States?
Oregon.
Oregon, it's a state.
It is.
Okay, let's imagine that now Oregon decides to become an independent state.
It wants to.
It wants to?
Yeah, the whole Pacific Northwest, Cascadia.
Okay, wonderful. So let's imagine that Oregon decides to become an independent state. What do you expect? What citizenship do you expect to have?
Cascadian citizenship.
So the citizenship of
Cascadia.
It will be called Cascadia, the state?
Indeed, yes.
Okay. Cascadian, why do you think that is? Why do you think you should have this this citizenship?
Because I'm still a citizen of my region, yeah.
This is as simple as it is. This is she actually told us what international law says about this. It's very simple. State succession. Cascadia became a state, independent state. She is a habitual resident as the text of international law says, a habitual resident of Cascadia. And yes, she is now a citizen of the United States. She doesn't have, this is the citizenship that she has, the United States of America. But at the moment that there is a state succession and there is one state becoming independent, all the habitual residents of this state automatically should become citizens of Cascadia.
And what if they don't want to?
Now, what if they don't give her the citizenship because she is Jewish? What would be the case? What would you say about that?
That would feel very unjust.
Right? So here there is the rule of non-discrimination has been violated. That's a human rights law. And the law of state succession also has been violated, because there is a law of state succession. Automatically she is expected to have the citizenship of Cascadia, and if Cascadia decides not to grant her a citizenship for some discriminatory reason or for any other reason, not necessarily because I don't know, it feels it has too many citizens and it doesn't want more you know?
Or just, I mean, just to throw, this is, my driver's license is Massachusetts. So I'm wondering, like, this feels somehow related. Like, I have been living outside of Oregon for a while. So how would taking it out of my life, but like, how would an international court rule for someone who was born somewhere and
the rule generally is habitual resident, and the way and this is how when the Ottoman Empire, for example, collapsed, and we started having all these entities, you know, the principle was habitual resident. So where are you habitual resident in the United States? If you are here or here, this is what, you know, this is generally what would be the principle.
Is that different than center of life?
I'm not sure actually.
Similar.
Similar, right? It seems similar to the center of life.
But where does the principle of state succession, where is it in international law?
It's not a treaty, but it is also it is codified. It's codified by the International Law Commission. So it is a custom that was developed over time and eventually codified by the International Law Commission.
Is it optional?
Yes, you can see, you can decide that you can choose not to take the citizenship.
And in that case,
but you should be offered the citizenship. In state succession, you should be offered the citizenship.
And what if it's not your?
If you choose not to, you don't get it. I don't know what you choose.
No, but then what would happen? Would it be? Yeah, would it be a problem in this very specific case if you're saying I don't want this really?
Well, if you don't want it and you want to become stateless,
passport,
where?
Do you stay? Do you leave? Like, what's the consequence?
If
the other scenario?
No, you shouldn't be obliged to leave. Also, citizenship is not the only reason for someone to stay. You can be a resident, obviously. You don't have to be a citizen to reside in a state. You can be a permanent resident. You can be but you need a status, obviously, if you want to live in a state. But yes, citizenship is not necessary, should not be imposed. And this was an issue that also came when the different states. This law of state succession actually developed after the First World War, so it's quite old. It's a custom that started developing after the First World War, because the victorious countries wanted to divide the Ottoman state and the Austro-Hungarian Empire into smaller entities, and they needed to come up with rules of how to do that. We were Ottomans at that time, right? I mean, our grandfathers were Ottoman citizens, nothing else. So they were not different from the person living in Istanbul or in Lebanon or in Egypt. Well, not Egypt, no, but let's say Lebanon, Istanbul. So yes, we had, you know, but at that time also an option to refuse the citizenship existed. But I don't think, and it wouldn't be, I didn't really research this specific question whether a person will have to leave if he refuses the citizenship, and I don't think that would be the case. But I know that this option existed. That's, yani.
The position of UNHCR is against deportations in such situations.
Deportations?
It now arise, yes, between Sudan and South Sudan, where Sudan wanted to deport people that were considered, in its view, South Sudanese, and UNHCR said that it shouldn't do that.
So Sudan considered that these people lost their Sudanese citizenship, yes, because now
there is South Sudan.
Oh my God. Although the international rule would say, if you live in Khartoum, whether you are originally from Khartoum or from the south, you should be still, you don't need to have taken the other citizenship.
Yeah.
Thank you. Is this working? You are. Yes. Okay. Now the right to reside in the OPT, in the occupied Palestinian territory, after 1967. What is the rule on that? Why is this illegal? And this is actually a complicated issue, which is even not written enough, I believe. When I looked for justifications and explanations on legality of the displacement, I actually didn't really find enough everybody takes the new ID card system for granted somehow. And you don't really find literature that discusses the issue fundamentally. Obviously, everybody says that the deportations and the transfers are crimes and illegal. But what I find is the appropriate way to tackle this issue is to criticize the system itself, when it was created in 1967. According to international humanitarian law again, which is also applicable at times of war and occupation, an occupying power has the obligation to recognize the law that exists in an occupied territory, right? The law that exists in the occupied territory includes your right to reside somewhere, your right to live in a place, in your home, in your city, your right to leave it, to come back to it, to move within it from one city to another. These are things that should be only, they should not be touched by an occupying power according to international humanitarian law. But what Israel did at the time was to introduce a new system, a new regime. Red ID cards, blue ID cards, orange ID cards, residency in Jerusalem, in Gaza, in the West Bank, and rules about how you can change from one place to another. And the rules became more difficult with time, as you remember. If you want to move, want to change your address, you need a special permit now, which you will not probably get, right? If you are from Jerusalem, you want to marry someone from the West Bank, the person from the West Bank needs a permit to enter Jerusalem and a residency status to live with you in the city. Despite the fact that before 1967, West Bank and Jerusalem were one entity. There was never an issue if I could marry someone from Nablus or from Jenin or from Hebron. It's not a question whether they can come and live with me in my house in Jerusalem, or whether I could live with them. Israel changed the whole system and introduced a new system of ID cards. And this system is illegal in its entirety, fundamentally illegal. The whole green ID card, blue, which unfortunately continued after the peace process. Next time I will talk more about the peace process, and I think it will be less boring than my discussion today, which is too legalistic. Next time it will be much less legalistic and much more subject. I know that legal discussion is maybe only interesting for lawyers, but still it's important for our discussion, because I always because if you want to take a position about something like the right of return, whether to accept it or not, it should be based on something which is this is why we claim we have right of return, right? This is why Palestinians claim they have right of return. You need to understand that there is legal grounds for this, and that this is why the international law is relevant to every discussion that we have, and to every initiative that we do. So this is basically this is the idea. And in the Geneva Convention, it's also stressed that the protected persons from occupied territory should not be affected if the occupying power changes some laws. That this change in laws, or any annexation of occupied territory, like the annexation of Jerusalem, should not negatively affect the population, should not affect the rights of the population, which is also not what happened. As we discussed, all this now in Jerusalem, center of life should be in Israel. If you go and live in Ramallah, you lose your residency. If you go abroad for a few years, you might lose your residency. If this whole thing is affecting the fundamental rights of you to be able to live in your city and to stay, and that is obviously also illegal. Finally, another element is the right to readmission. There is in human rights law this idea: no one shall be subject to arbitrary arrest, detention, or exile. This is Universal Declaration of Human Rights. Everybody has the right to leave any country, including his own, and to return to his country. Everybody has the right to return to his country. Also, Universal Declaration of Human Rights. The International Covenant for Civil Political Rights. No one shall be arbitrarily deprived of the right to enter his own country. And why did they use to enter? And this is important. I want to stop at this element. The difference between return and enter. At the beginning there was the text return, and then there was the text enter. They actually use the text enter because somebody can be born abroad, descending from people who had the right to return, but maybe did not get that right, or was born abroad. In that case, he's not returning, he is entering for the first time in his life, but he has the right to enter. And this is the whole discussion about the children of the refugees and the grandchildren of the refugees. We always get asked, well, you know, 750, 800, whatever, thousand people were displaced in 1948. How come now we have to bring back 5 million people? The right of return. Why is it for? Because maybe they don't have the right of return, but they have the right to enter and be repatriated, right? Which is basically the right of return. That's it. So, you know, again, because this comes always in discussion. Again, it's important to. Okay, and there was another thing that I wanted to say in that slide. Can you go back to the slide, please, before we go to this? That there is another element that no state should be forced to accept foreigners. The fact that you deport someone, or that you even revoke his citizenship, or do not give him a citizenship, deny him a citizenship, in order to deport this person, this is not only violating his own right or her own right, it also violates the right of the state that has to receive him. Why do you force other states to receive somebody who is not their own citizen? So these are the general reasons why displacement is illegal. I wanted to finish this presentation by this slide. This slide is an Israeli law, actually. This is an Israeli law, which is, I found it really interesting that Israel, after the Nazi regime committed the Holocaust, the genocide against the Jewish people, Israel decided that it wants to keep the right to prosecute criminals. And who knows who was prosecuted according to this law? Eichmann, as one person who was prosecuted according to this law. Sorry? Yeah. And according to this law, Israel even recognized that deportation, as you can see, I have underlined the word deportation here, and deportation, forced labor, etc. That Israel recognized that deportation, that forced displacement, is a crime. It's a war crime and a crime against humanity. And this was in 1950. But, unfortunately, we cannot use this law to prosecute war criminals in Israel itself, because the jurisdiction of the Israeli courts, according to this law, is only related to crimes that happened during the Nazi regime, or by the Nazi regime, and during the Second World War, mainly against the Jewish people. Although not necessarily, there is also the element of crimes against humanity, which can be also, the victims can be not only the Jewish people, but it has to be linked, nexus to the Second World War, not anything that came after that. So this is kind of, but I find it really interesting that Israel recognizes that deportation is a crime. But if it's a crime that happens according to some people, not others. And this is, this is where I wanted to end this presentation. If anybody has questions, something to discuss, please.
Well, the thing is, this is also a retroactive law. You can say it's also based, just as you said, that we would base the one, I don't remember which country it was. So you could say, again,
Estonia.
Yeah. So just like the Estonian one is based on the already existing international law, so it's just the same.
Of course. And why do we? Why did I go as much back as the First World War, actually? Because it's always important when in legal arguments to make sure that something was a crime before the crime happened. Because if it wasn't, then we're not talking about a crime. We're not talking about illegality. And therefore, if something was not illegal, then there is no need to fix it. Then it was right. And if it was right, then we're okay. And that's the whole discussion. And the whole discussion now is about right of return, which is not today's topic, actually, but everything is based on the illegality. Why is there a right of return? Because displacement is illegal. And it should be fixed, right?
So the idea is that even if Israel said that they're limiting its jurisdiction according to this law to the Nazi regime, still, if it says deportation is illegal, it has to go back to the whole concept of deportation being illegal. So Israel not only regarding the Nazi regime.
Yeah.
No, it's not because of this law. It's because it's under customary international law.
Yeah, but I mean, it's not. Generally, also it can be said that Israel actually acknowledged that customary law, that customary international law.
In a sense, yes.
Yeah, it acknowledged, and while it actually created a retroactive jurisdiction, it also recognized that when the crimes happened in during the Second World War years, they were illegal already, and that has an important significance. And so yeah, we're talking here about a continuous crime that's happening every day, and again, it's a war crime and a crime against humanity, systematic. From what we discussed before, do you see that it is systematic displacement? Obviously, it is. So we're talking about daily crimes against humanity happening. Even if it is not at gunpoint, although in many cases it is at gunpoint or at bulldozer point or at ID revocation or whatever, but it's very systematic, it's very organized. You saw how organized it is, how legalistic it is. Yes?
I guess I was wondering about the selective application of international law. So you kept mentioning it was kind of brought about by agreements by the victors.
Yeah.
So it wasn't used, as far as I know, against Dresden or Japanese internment.
Exactly.
How is that applied, I guess, here? Because you have, I guess, mostly focused on nations that have just experienced massive military defeat, which Israel has not.
Yeah.
So, like, what are the barriers to actually applying it?
Yeah, unfortunately, it seems that international law until today is actually on the ground is applied on the weaker and on the defeated and on the. So as you said, the crimes that were committed by the English or the French, the burning of Dresden, was never prosecuted. They didn't give the court jurisdiction to do that. The state, when it wants to prosecute, it prosecutes according to its own interests. And the international legal system also now, with the United States General Assembly, Security Council, would never punish except if all the 5 powerful countries in the world decide to punish a state. So if Iraq did something, it's okay. They feel Iraq violated international law, they sanction Iraq or Iraq. But if a country that is friendly with either the United States or Russia, and they want to protect it, they protect it. They veto any decision, and that's it. This is the problem with international law.
Yeah, well, the ICC is an attempt to remedy the situation, but the accession to the ICC is voluntary by states. So.
Exactly.
Is there any precedent of a non-victorious or of a person from a non-victorious nation who has been prosecuted by international law?
Yes, of course. No, the ICTY or the ICTR, there was no question of victorious or not victorious. All parties to the conflict, all parties to the conflict, for instance, in Yugoslavia,
were defeated by NATO, but okay.
Continue.
Yeah. No, but maybe you have a plan.
No. The thing is that
no, for instance, now there are proceedings against Bashir, the president of Sudan. Now, he hasn't been arrested yet, but he's indicted in the ICC, and he hasn't lost any war, but he's wanted for crimes against humanity. So it's not that the international community is impartial, but there are attempts.
Yeah. I think the implementation of international law needs generally a lot of reform, to be honest. I mean, it is still very imperialistic somehow. Like these big, powerful countries really control more or less what happens. Can you imagine, anybody who's responsible for Guantanamo, for example, to be prosecuted in any court in the world? We don't expect it because we know the United States will not allow it, basically. And in the same way, until now, in Israel has been quite protected from international law, and both the leaders and the state itself have been impunity from any.
Even Bashar al-Assad is being protected. I mean,
also Bashar al-Assad.
He is committing crimes against his own people, and not only did they not prosecute him, they actually kept him.
Yeah. The world is fighting him, but not fighting him to defeat him.
No, they don't want him to leave. I mean, they don't know what's going to come instead, but he's actually being supported by the West.
I don't know if supported, but he's not
He
being
is supported
enough.
because he hasn't been ousted. Okay, we'll take your chemical weaponry, but we'll leave you as ruler of Syria.
The thing is that international law now is not ruling the world. It's more interests of states and different politics are ruling the world, and not international law. But still, I believe that international law has significance when we want to start drawing our policies. At least when we are in this room thinking about what we want, we need to refer to international law. When we start a truth commission, for example, Aniva, this is where we need to come back to international law again and say that, these are the principles that we are bound to because we support human rights. So,
Today, before I came here, I watched a bit of TV on the internet, and they were talking about the act of deporting the person who shot the 4 people in the synagogue. They were talking about deporting his wife, who was brought from. I mean, she's not. I don't know where she's from, the West Bank. What's that? And then they were saying, well, there are certain laws against deportation. You can't deport someone who doesn't have another nationality.
Yeah.
And then it said, oh yeah, well, but the Palestinians, they were all Jordanian. And in that moment I said, but I've learned something. Jordan actually revoked her citizenship from these people, so they cannot be by international law.
Yes, there was this engagement. There was this engagement in '88, and there is no citizenship. But even if she had the citizenship, she cannot also be deported. She shouldn't be deported. She's living in her house. See, this is the thing. From Israeli point of view, she's living legally in Jerusalem because Jerusalem is part of Israel, because Israel annexed Jerusalem. From international law point of view, the annexation of Jerusalem itself is illegal. And the blue ID card that her husband has is an illegal, and the whole system is illegal. And she should be free to live in Ramallah or Jerusalem or the West Bank or or anywhere within that territory freely, without being opposed. So here we have 2 standards. We have the international law standard, which is here, and we have the Israeli standard, which is here. And all of us, the lawyers, we are working here under this system, unfortunately. I also we have the Community Action Center, which is the director of. We give legal service to people. We work under this ceiling, not under this ceiling. We see that one from below, like this, but we know that it's far away. We know that this is not our limit. Our limit is here.
But she was brought to Jerusalem from the West Bank.
Yes.
As Ichud Mishpachot.
Exactly, which is wrong. We shouldn't have Ichud Mishpachot for people who want, which is family unification. We should not have family unification in the first place between the West Bank and Jerusalem, because Jerusalem is in the West Bank. It's one territorial unit. If you are from Nablus or
not only that, but now they are actually stateless because the Jordanians revoked their citizenship. So
yes. But this is true for all West Bankers. If Jordan revoked their
but that I learned from.
That's the problem, that we apply for, in my center that we work, we apply for family unification. We make arguments for family unification in front of because that's the only thing in front of us. But we know that the whole system of family unification is wrong, should not exist.
But the revocation of citizenship by Jordan is not in itself a very
friendly thing to do. Yes, but it is a fact that actually all those people have no nationality, really. They have no citizenship anywhere.
Yes.
So it is illegal to leave them in this situation.
Yeah, we became more stateless, and there are rules in international law also that try to fight statelessness and to. But yes, we're becoming more stateless, and obviously the all Palestine government that I mentioned last time didn't really produce a real citizenship, unfortunately, and wasn't recognized. So yes, most of the Palestinians end up being stateless, whether we live in Palestine or outside Palestine. I think it's time for a break. I feel that I might have taken too long. It's 34, maybe. It's okay. A resolution 194 of the United Nations General Assembly. That was issued in 1948 while the war was still going on. According to this article, I'm sure many of you must have seen it, must have read it, must have encountered it. It calls on the return of the Palestine refugees. This term, Palestine refugees, was actually the name that was used. We now say usually Palestinian refugees, but in 1948 and even until today, the term was Palestine refugees. And why did they use the term Palestine refugees? Because there were also Jewish refugees, obviously, from Palestine, from general Palestine. Jewish refugees who were maybe living in Jerusalem or in Hebron, who went and were displaced to the other. But these were small in numbers, but they existed, obviously. And there were also Arab refugees. Now Palestine was the one entity that actually included all of these Jews and non-Jews, Arabs and non-Arabs. I don't like to always say Jews and Arabs because Palestinians are not only Arabs. You could be Armenian, you could be, there are different types of original. So let's say Palestinians, not Jewish, if Jews are one nationality, then let's accept that for a moment and say Jews and non-Jews.
But was that the reason, because they were also Jews? Or in 1948, was anyone defining himself as a Palestinian as opposed to Jordanian?
Yeah. At that time, everybody was Palestinian.
At that time, like the PLO was only founded in 1968? Or
well, the
self-determination for Palestinians was evolved gradually.
Actually, no, there was, which is something I discussed last time. Okay. In 1948, there was an announcement of Palestinian statehood and a government called the All Palestine Government, حكومة عموم فلسطين. It was the head of this state was Mufti Haj Amin al-Husseini, but he wasn't actually the leader. The actual leader was someone from Tulkarem called Ahmed Hilmi Abdel Baqi. He was a prime minister. He was based in Gaza City. And they issued Palestinian citizenship, and they had an army, weak army, but it existed. But Jordan, anyway. But this is so. There was something called Palestine that came out of Palestine, but the All Palestine government claimed all of Palestine, and obviously this had two problems: Israel, which had the most significant part of Palestine, and also Jordan, which also annexed, an important part of Palestine later. So the dispute in Palestine was bigger than the All Palestine government to control. But yes, the term Palestine refugees was there in order to include also the Jews. And the UNRWA also, which I will talk about here, which was established in basically in a resolution in 1949, and it started its operations in 1950. was actually established for all Palestine refugees. But then in 1950, what is it, 52? I think 52, Israel decided to take responsibility of all the Jewish refugees. So there was a difference in the way the different states dealt with the refugees. Israel decided, I don't want to keep the Jewish refugees as refugees. It didn't really care about this issue of right of return to here or there. It took the responsibility of the protection and the relief and all the responsibilities related to the Jewish refugees from let's say West Bank or Gaza or whatever it was. Here we're not talking about the Jews who came from Morocco or from Egypt or from Syria. We're talking about the Palestine refugees. This institution, the UNRWA, was created for the Palestine refugees mainly, most of whom were Palestinians, not Jewish Palestinians, who are also Palestinians, obviously. It gave its jurisdiction. It was established to give services to the refugees, obviously under the understanding that these refugees should be allowed to return to their homes, according to the Resolution 194, which came to recognize general international law that had existed before the 1948 war, as we maybe discussed earlier today. But then it was understood that it doesn't seem that the refugees will return quickly. The numbers of the refugees were big, and they needed relief. The Palestinians who were displaced from their homes, they really went through very difficult conditions after the war. Hunger, starvation. They were, maybe landowners or workers or farmers. They had to leave all of their livelihoods. They had to leave all of their belongings and go. And some of them didn't know any other profession. Some of them were farmers. What is a farmer without the land? What can you do? So the financial condition, the humanitarian condition of the refugees was quite severe, that the United Nations had to do something. Obviously, it was also criticized somehow by Palestinians. Obviously, the UNRWA has criticism by the Palestinians and by Israelis from different points of view. One of the Palestinian criticisms of UNRWA is that UNRWA was actually institutionalizing refugeehood instead of actually the international community pressuring the return that it has demanded from Israel, that it was actually making sure that this is durable, that the refugeehood is durable. But on the other hand, we don't know. What if they didn't do anything? Maybe people would have died out of hunger, or they would have starved or something. So eventually this organization was built, the United Nations Relief and Works Agency for the Palestine Refugees, and it was established in order to take care of the Palestine refugees. And now it is one of the biggest and most important institutions in the Middle East. It functions a large number of schools, hospitals, all different types of institutions, more than 20,000 employees. It has an enormous budget compared to, it is quite a serious organization that has now lived as long almost as the conflict, basically. Yes?
Why is eligibility passed along through the father?
Only through the father, which is also something that has been criticized. Because also, apparently, the UNRWA believes that they care more about the bread owner. If the bread owner, who's usually the male, according to the understanding, is the refugee, then the refugee is the one who passes this status. The women do not pass, and obviously Palestinian feminists and women rights generally, not necessarily feminists, women rights advocates criticize this. They have and they continue to criticize this. But there is one thing that I want to also make sure we understand, and that is, I think something that is usually outside the table. People normally think that Palestinian refugees are the refugees that are registered in the UNRWA. Somehow people equate between the UNRWA and having a status by the UNRWA and the refugee. While this is maybe functionally true somehow, but this is not true in terms of other rights a refugee might have. So what is the jurisdiction of the UNRWA? The jurisdiction of the UNRWA is simply, it has territorial jurisdiction, actually, which is this one. It has territorial jurisdiction over the certain refugee camps and certain communities that are living in the West Bank, Gaza Strip, Jordan, Lebanon, and Syria, right? So any refugee who was displaced in 1948 initially, and important to mention, also 67, in 1967, new refugee camps were built for those who were displaced in the 67 war, especially in Jordan, actually. A number of new refugee camps were built for Palestinians. And so the UNRWA also took responsibility over new refugees. So the UNRWA definition of a refugee, according to UNRWA concepts, doesn't necessarily mean that whoever is not under the UNRWA system is not a refugee, or is not displaced, or does not have right of return, or does not have title to his lands or her lands, or any other things that that people might claim. And this is something that is important to mention, and it's quite forgotten in negotiations. Always we think about UNRWA. UNRWA now has 5 million refugees, 59 refugee camps. When we talk about refugees, we always discuss these numbers. And these numbers don't reflect the reality of the refugees. So what is the total number of displaced persons, refugees? I actually don't know. It is quite big. We know, as I mentioned maybe in the first class, something in the first meeting, something between 66 to 70% of all Palestinian population has been displaced. This means that there are rights, which maybe and remedies, which we will talk about next time, that all of these people should be entitled to. But the UNRWA, as well as UNHCR, which we will talk about later, are not there to define what happens or what are the rights of the refugees in their country of origin. It's more about the relief. What do we do with a person while this person needs our protection, while this person needs our aid, our financial aid, our food aid, etc. And that's what the UNRWA is doing. But obviously the UNRWA in our context is also very political, because it actually serves 5 million Palestinian refugees. quite a big population. That's a whole state. 5 million is not a small population.
Why is the UNRWA's definition of refugee different than the UNHCR one? Why in the UNRWA's case it can be transmitted, and in the other case being a refugee is a personal right?
This is the reason why UNHCR, this is one of the main reasons why UNHCR does not have jurisdiction over Palestinian refugees. And this is something I was going to talk about in the next slide, actually. When the international community was discussing and signing the convention relating to the status of refugees, 1951, they were defining who is a refugee. One element that came up in the discussions, mainly from Arab countries, was we do not want the Palestinian refugees to dissolve among other refugees in the world, and we also the Arab countries don't want to absorb the Palestinian refugees eventually. They would like them to keep the status and return. This is normally the Arab countries' position. So, but one of the approaches is the UNHCR. It doesn't want to keep the responsibility on more and more refugees. It wants to get rid of refugees. If you manage to get a citizenship, you don't get protection from UNHCR. But in the Palestinian case, If you get a citizenship, in the case of Jordan, all of the refugees, most of the refugees who live in Jordan have a citizenship, with the exception of those who were displaced from Gaza in 1967. They don't. But most of them, they have a Jordanian citizenship, but they still receive UNRWA support until today. UNHCR, if you manage to get a citizenship of any country, you lose the protection of the UNHCR and the aid and the and this was so. This is what happened. This article, Article 1D of the UNHCR, was designed for the Palestinian refugees, basically.
Just one moment. Why was that definition accepted? Why did they make a separate law for the Palestinian refugees?
Because they have a specific institution called the UNRWA.
Yes, but is it because the hosting nations literally didn't want them?
Yes.
No, but generally states don't want refugees.
Refugees. That's
so it's not
always
no,
the
but
case.
why was the law changed for in UNRWA in the Palestinians' case, in the sense that even though they have Jordanian citizenship, they are still retained
as refugees?
And
because this is how the UNRWA system is since its beginning, which was before UNHCR was created. UNRWA was, 3 years before UNHCR, and according to the rules, yes, Jordan did give a citizenship to all of the refugees in 1948, and to the West Bank, to all of the citizens of the West Bank also. But it also, there was a position also that these people are refugees. They have entitlements in what became Israel. They have lands, and they want their lands, they want to return, so they keep the status of refugees. They believe somehow, there was a belief that if you keep the status of refugee, this will somehow keep your right of return. And until today there is this feeling. Now, in my opinion, according to my own research, I know that this is not the case. You can get any citizenship you want in the world, and still, if the right of return becomes available, you can claim it. When it becomes available, you can claim it, because you don't need to be taking aid from an agency in order to claim your rights.
No, but it seems that the issue here is whether the people actually wanted that foreign citizenship. Once they wanted it, once they claimed it, they in a way revoked or said, no, we don't really want to go back.
It depends. I'm not sure. Look, I know that in Lebanon and Syria, they always say, no, we don't want the citizenship. In Jordan, they got it immediately, and they are happy with it, and I think it's great that they have it, to be honest with you, and I think that Jordan did the right thing by giving them citizenship. Now, in Syria and Lebanon and Egypt and other places, they didn't get the citizenship, and I'm going to talk about this later, but they usually say, we don't want the citizenship. The Palestinians, maybe out of pride or out of I don't know what, they usually say, we don't want the citizenship. They also feel that citizenship, I've heard this many times, they feel that citizenship might actually undermine their right of return. While I argue this is, at least legally speaking, not true, but once somebody becomes a citizen of a state, the urgency of their situation becomes less important. But how urgent it is, we are 66 years after the displacement, so I don't think we are in such an urgent situation anymore.
It still leaves the question from the Palestinian point of view. Why were those in Jordan happy to get a citizenship and the others didn't?
Yeah, I believe everybody would be happy with the citizenship, to be honest with you, because you need rights. Okay. You need rights, and in
so it's not out of some kind of pride. It's the other states didn't grant them citizenship.
Of course, I think if the other states, okay, now I'm predicting, right? There is something I know and something I predict. I know that they say that there is this general speech and general discourse that they don't want the citizenship. Now, if this is actually true, if they, in the bottom of their heart, they actually want it, but they say they don't because this is the discourse, I'm not sure. right? So I cannot tell you what. But I mean, I've met some people who left. For example, I met this guy who left Lebanon, who also grew up in Saudi Arabia, which doesn't give citizenship to anybody, obviously. And he was a refugee in Lebanon. In Lebanon, he has no rights almost at all. There are 70 jobs that are forbidden to Palestine refugees specifically. You cannot work in these jobs. Education is very complicated. You cannot study. You have to go abroad if you want to study. So they are very limited in their rights in Lebanon. So they always, anybody who manages to leave, they leave. So obviously he went to Britain and he managed to gain a citizenship eventually after a struggle. Not a big struggle. Britain actually is, better than most countries in our region in that case. If you go there, you live a number of years, you have a situation, they respect your situation, you live a little bit and you get a citizenship. But so this guy ended up getting a citizenship. Actually his case was funny. I don't know, did I mention it before? He when he was being interviewed, basically he stayed as a student at the beginning and then his visa expired. So the immigration wanted to deport him. They said, we want to deport you. He was, okay, deport me. Where is your country? He was like, Palestine. It's true. He has, his document is a Lebanese travel document for Palestine refugees. So he's not Lebanese. Which one is his country according to everything? Palestine. So he said, Palestine, I'm from Tiberias, yani, Lake of Galilee. Deport me there. So at the beginning, the woman, she doesn't know what to do. Obviously, she says, okay, Palestine. Then she looks, she doesn't find a Palestine. He told me the story. She doesn't find a Palestine. There is nothing. And then they had to keep him because there is nowhere they can deport him. They cannot deport him to Lebanon because he's not a citizen of Lebanon. He's just a refugee. He's stateless refugee.
It's amazing that he got a student visa.
Yeah. Yeah. Sometimes they do. Sometimes they do get visas, but it is complicated for them. Actually, every time, because even when I apply for visas and they ask for citizenship, I usually write stateless. And when I write stateless, sometimes Britain understands, it's okay. But sometimes at border they ask me, why did you write stateless? You're Jordanian. No, I'm not Jordanian. Do you want to know the story? Then I tell him the history of the Palestinian-Israeli conflict. If he has time, I also have time always for that. In airports, but yes, they do give sometimes. Obviously, it takes more time. They are more careful, but they do give visas. You wanted to ask something?
Yeah, I'm just curious. I'm wondering, besides Jews and Palestinians, is there any other group entitled to a right of return that can be transmitted?
Yes, all the groups, everybody. Everybody in the world is entitled to right of return if they were displaced from somewhere forcibly. This right is not only for Palestinians or for Jews. If you were displaced from somewhere forcibly, so an international crime was done against you, and you were not, and you became a refugee or a displaced person internally, you have you have title to your property.
So maybe the term refugee is not appropriate.
No, exactly. The term refugee is not sufficient to define the problem.
Exactly.
The word refugee is one issue. The word refugee is actually not the term that is related to right of return. It is related to the host country. The host country is hosting a refugee. The refugee is a status that I have when I am displaced. I seek asylum in France. Are you from France? Belgium. So I seek asylum in Belgium. Then I'm a refugee in Belgium for the duration of my stay in Belgium. Then if I become a citizen of Belgium, I'm not a refugee in Belgium anymore, I am a Belgian citizen. But this doesn't mean that whatever I left behind in my own country is not mine anymore. If I inherited a land, it's still mine. If I own a house, it's mine. If I have a citizenship, if I have another citizenship, many Syrian refugees who went to all around the world, they are still Syrian. They didn't lose the fact that they come back to Syria eventually, you know. So this is the point, that the term refugee is not the main issue, although in the negotiations and in the political sphere it is the issue, but it is not. For me, any person who has been displaced, this is what the way I would pronounce it, that anybody who was displaced has the right to return, whether displaced internally by population transfer or deported, has the right to return to wherever he or she was from. This is the simple rule. Now, whatever you gain citizenships or statuses while in the journey of your displacement is a different question.
Munir, I think we need cable
for the computer. Yes, that's true. I have it. It's because I have the computer. Here, according to UNHCR, this convention shall not apply to persons who are at present receiving from organs or agencies of the United Nations other than the United Nations High Commissioner for Refugee Protection or Assistance. So this is basically, there are two agencies in the world, the UNRWA and the UNHCR. The UNRWA is for Palestine refugees. So this text was created specially for Palestine refugees in order to exclude them from the protection of the UNHCR, in order, because they have the UNRWA, obviously. There is another agency. They didn't, the Palestinians, the Arabs, different stakeholders didn't want to, or the UNRWA to dissolve, and they didn't want the Palestinian refugees to dissolve among other refugees.
Why?
Sorry?
Was that part of the, like, they were worried if it went under the General Refugee Commissioner, then it
first they will lose.
Easier for them to stay in the host countries?
Yes, of course, and that's the case. It will be easier. They will lose the status of refugee. UNHCR and convention relating to the status of refugees makes it easier to lose the status.
Okay.
So after after one generation or two, you lose the status. It doesn't keep going and going. And again, the status is different from the idea of return and all of this. But also, look, for example, Lebanon never wanted to accept refugees, especially Lebanon. Lebanon has demographic issues as well, like issues we have here. It had somehow a Christian majority at that time. There were Palestinians coming, most of them were Muslims, some of them were Christians. They didn't really want to change the demography like that, so they didn't want to accept all these refugees, and they still insist that they don't want them to feel stable, basically. But also all the other countries maintained. Also, generally it was seen that these refugees have to return. This is somehow a principled position that the Palestinians had, but also generally the Arabs somehow had, until today. That this is the right that should be given. Return to their homes. Obviously it's not happening, but they felt that if the Palestinian refugees lose the refugee status, they would lose their rights, which I'm not sure is the case. I mean, it will make it easier probably if you think about it. As long as you're refugee, still it's more. It looks more urgent somehow. Yes.
But why in the other organization, after 20 years, you can't continue to be a refugee? Is it because their problem was solved, or what is the?
No, they make different. More criteria in order to lose your status of refugee, and to gain it. And to gain it, they make it more what?
To get a refugee status, according to the convention, it's not enough that you've been displaced.
Yeah, you have to fear.
Yes, you have to fear return for 5 specific reasons.
Yeah.
It's different.
The
whole concept is different.
Yeah.
Found fear of persecution because of because of your race, political views, belonging to a certain that's like certain social group.
Yeah. So yeah.
Munir, in the same vein, is there something analogous to Resolution 194 for any other refugees in the world? I guess the UN granted the right of return to other refugees.
Of course, of course. Like Bosnia, for example, there was a Security Council resolution. There were, look, in general, even 194 was always used as, so, despite the fact that it didn't help Palestinian refugees, but it actually was always used as evidence that there is something called right of return to refugees. It was used to show that there was customary international law, and in any refugee case, anybody who's claiming right of return, this becomes an issue. Most of the times, see that the funny thing about the refugee law is that the whole idea, the most important principle in this refugee law is what it's called in French, non-refoulement, which is, I don't know because it doesn't have a term in English. It's actually the French term is the one that is used in English. Is it a good pronunciation?
Yes.
Merci. Which means that a state that hosts the refugees should not force them to return to where they might be persecuted. So the whole discussion is even different. While the Palestinian issue is always about the right of return, the rest of the world is fighting for the right to asylum. The right not to return, which is also a right, by the way. I mean, right to return has another opposite side of it, right not to return. Nobody should be forced to return. And this also applies to Palestinians, by the way. It's not only applies to the rest of the world, in a way, but in the rest of the world, it's the more, it is the one that is really stressed more that you should not force somebody to return to where they were persecuted. Normally, it's not very usual now to find anybody disputing right of return. It's really rare. Bosnia, Yugoslavia was this because of the ethnic cleansing. Obviously, they had similar issues, and there was obviously NATO intervention and UN intervention and everything. But usually it's not an issue. Yeah.
But wasn't the right of return recognized even before the Palestinians, like
course.
in German occupations and
of course.
all around Europe?
Of course. So it was already customary. It is something that is stable in international relations. It's not something only for Palestinians. And all of these people who are taking services from UNHCR, when they lose their refugee status, which is what we were discussing, after they lose their refugee status, after they become Belgian citizens, they still have the right to return.
The refugee status is temporary.
Refugees is a temporary status. It's not supposed to last forever.
Exactly.
It's something to help you to get along with your life until you manage to gain a citizenship, gain a residency, return to your country. Obviously, once you return to your country, you're not a refugee anymore. If you return voluntarily and everything. So, you know, it is a temporary state. But with our conflict here, it's not temporary because it's yeah. So now the refugees and their conditions in different places. In the West Bank, we have 750,000 refugees from Israel, basically. And in Gaza, we have 1.2 million refugees out of 1.5. So the majority of the population of Gaza are actually refugees who came from areas that are, that became Israel in 1948. In the West Bank and Gaza, the Palestinians who are in refugee camps or outside refugee camps are equal to all the other Palestinians in terms of the status. They have the same ID card, the same residency status that the rest of us have, the rest of the people in the West Bank and Gaza have. And they get UNRWA aid. And still UNRWA schools, they learn in the UNRWA schools, they get UNRWA medical services. Most of these services are free. They get aid, food aid sometimes for very poor families, financial aid when the bread owner is dead or disabled, they get money aid even. So that's that's in the West Bank. Now in Jordan, as mentioned before, the Palestinians or very quickly became citizens, full citizens, just like any other Jordanian. Most of them, with the except of the refugees the refugees who were displaced from Gaza Strip in '67. And it's really surprising how they were displaced from Gaza all the way to Jordan. Not to Egypt, for example, but they were displaced to Jordan.
But they are also discriminated against in Jordan.
Who?
Palestinians.
In certain ways, not in the same way. I mean, they are socially...
not only so.
How?
They have troubles renewing passports, getting visas, all...
The citizens?
Yeah. Who are Palestinians? Also.
You mean the ones in Jordan or the ones who are in the East Bank?
Both.
Look, to the best of my knowledge, those who live in Jordan and have a citizenship, they are treated generally in the same way. At least in the general legal system, they renew. When they renew a passport, they renew it in the same day they get it, and they. So it's quite. That's the best of my knowledge. Now I don't know about how other methods. Now they complain sometimes about discrimination between Palestinian, Jordanian, and most of the population of Jordan is Palestinian, and most of the wealth of Jordan is also with Palestinians. The banking business, the shops, it's mainly Palestinian. Jordanians are more in the government bureaucracy or different levels of government. But really, the wealth of the country is more in Palestinian hands. So you hear of some sorts of discrimination, maybe, but not something, not major in Jordan. The major discrimination against the refugees is in Lebanon. Now, in Syria, they, and let's say in Syria generally, not in Syria after the war, because we will maybe discuss a little bit after the war. But in Syria generally, they have had a residency status that is, given to the refugees. They have a lot of rights. They can buy houses. They can leave the refugee camps, buy houses in other places in Syria. Actually, I hear that refugee camps themselves, sometimes there are many Syrians who live in the refugee camp because it's cheaper than other places. So they manage to get free education like Syrians. They manage to get lots of. Generally, they get treated as citizens, with the except of the fact that they, like permanent residents, they cannot vote in the parliament, which anyway the Syrians don't really benefit from. So it's not really that significant of a difference from the Syrian citizens. But other than that, they get almost the same rights as the citizens. The worst situation in the UNRWA mandate is Lebanon, where we have 450,000 refugees that have a very limited rights. They have the poverty there is very low, very high, because they cannot do many jobs that Lebanese are allowed to do. They cannot own houses outside the refugee camp. You cannot, if you're Palestinian, if you're foreigner from other parts of the world, you can buy a land or a house in Lebanon, but Palestinians cannot. So they are really under very hard restrictions there.
And if you were born there in one of those refugee camps?
Of course. Most of them are born now. Now we are 4th generation of refugees.
No, but they are allowed?
No. They are stuck. They are stuck in refugee camps unless they manage to go to London and say, send me back to Palestine, yes. But usually they're stuck, and there is a lot of people from there trying to do illegal immigration. They do all different tries, and they will try once and twice and 3 times and 4 times and 5 times. They will do their best to leave if they can, because it's they cannot live. You have no future. You cannot get proper education. You cannot get a proper job. You cannot live wherever you want. Even if you manage to go to work in Saudi Arabia, you save some money. You want to buy a house. You cannot buy a house. Then you find somebody Lebanese. You buy the house and you buy it in their name. But then how do you guarantee your right? You know, it's like a whole, complicated situation there.
I'm sorry to ask you, but this is so interesting.
Yeah.
What if a refugee in Lebanon marries a Lebanese?
Yeah.
How does
a woman or a man? I think the difference is the woman or a man. Usually a woman, I'm not sure about the Lebanese law, but usually in what I see in Arab, if a woman marries a man, she will even end up getting his status. And I actually know a case like that. I know a woman who married a man, and I took her one time. She's Palestinian from Haifa. So one time we went to Haifa to look for her house in Haifa. And I think we found it. It was a house with a طحينة معصرة طحينة يعني like sesame how do you press طحينة press sesame press that makes طحينة. We found it. But anyway, so she married a Lebanese. She's Lebanese as well. But the other way around doesn't work. If she is Lebanese and he is a Palestinian, he doesn't end up getting. And the children will be refugees, usually. That's a problem. In Egypt recently, during the Morsi government, children of Egyptian women who have Palestinian fathers gained citizenship only during Morsi recently. Now the current government wants to revoke this citizenship already. So look, also the Palestinians, and that's something I also wanted to talk. The Palestinians are always victims of things that happen in the Arab world. Now in Iraq, which is outside the mandate of the UNRWA, you remember what's the mandate of the UNRWA? Syria, Jordan, Lebanon, and then West Bank and Gaza, Palestine. تمام? Iraq is outside, so the refugees in Iraq, they are under UNHCR. So exactly, in that case, UNHCR has jurisdiction. So it's not totally doesn't have jurisdiction over Palestinians. As long as Palestinians are under protection of UNRWA, or let's say jurisdiction of UNRWA, UNHCR has no jurisdiction over them. Once they leave that jurisdiction, they become, they get the services of the UNHCR. So in Iraq, they have the services of UNHCR.